Representative Casimiro.
Present.
Representative Corvese.
Present.
Representative Felix. Representative Lombardi.
Present. Present.
Representative Norrie.
Here.
Representative Place. Representative Roberts. And Representative Bella Wilkinson. Eleven present, 4 absent. We have a quorum.
Thank you very much, Madam Clerk. Welcome to the House Committee on Judiciary. It's Tuesday, April 27th, 2021. We're in the House Lounge. We've got, let's see, 3 bills for a hearing and/or consideration, and 1 bill where we will vote tonight. Let's deal with the procedural stuff first. With reference to the bills that are scheduled for hearing and/or consideration, can I have a motion to hold those bills for further study?
So moved.
Second.
Roll call?
Chairman Craven.
Yes.
First Vice Chair McEntee.
Yes.
Second Vice Chair Knight.
Yes.
Representative Agello.
Yes.
Representative Batista. Representative Bennett. Representative Caldwell.
Yes.
Representative Casimiro.
Yes.
Representative Corvese.
Yes.
Representative Felix. Representative Lombardi.
Yes.
Representative Norrie.
Yes.
Representative Place. Representative Roberts. And Representative Bella Wilkinson. The ayes have it, Chairman.
Okay, thank you. And now we have 1 bill scheduled for consideration. It's a House Bill 5376, sponsored by Representative Donovan. It's an act related to health and safety. It involves balloons. It prohibits the release of balloons inflated with lighter than air gas, subject to a $250 fine, effective November 1st of this year. And we do have a sub A2. And our legal counsel has got an explanation for us.
Thank you, Chairman. The sub A2, Rep. Donovan is correct. They changed the penalty section. So the present penalty, the initial bill said up to $500 for each offense. This one says $100 for the first offense and up to $250 for a second or subsequent offense. In addition to that, in the penalty section, language was deleted that stated the release of multiple balloons at one time should be considered a single offense for the purposes of this bill. That was deleted and the penalty was changed. That's it. Those are the only changes.
Okay. So if there are any discussion or questions, do I have a motion to pass?
So moved.
I move that we pass House Bill 5376, Substitute A, and hold and indefinitely postpone the underlying bill.
Okay. Is there a second? It's A2, by the way.
A2.
Substitute
Okay.
A2.
5376, Substitute A2.
Okay. There's been a motion, and I heard a second somewhere.
Edie.
All right. Roll call?
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Yes.
Representative Agello.
Yes.
Representative Batista. Representative Bennett. Representative Caldwell.
Aye.
Representative Casimiro.
Yes.
Representative Corvese.
Yes.
Representative Felix. Representative Lombardi.
Aye.
Representative Norrie.
Yes.
Representative Place. Representative Roberts. Aye. Was that an aye? I don't know who said that. Representative Place?
Yes.
Okay. It was a yes on the vote?
Yes.
Okay. Representative Roberts? And Representative Bella Wilkinson. The ayes have it, Chairman.
Okay. Congratulations, Representative Donovan. I know it was up in the air the last couple of years.
That was good. I was trying to say that.
65 years I've been waiting to say that line. Okay, let's go to the first bill that's scheduled for hearing, House Bill number 6215, sponsored by Representative Agello. It's an act related to property, Rhode Island Fair Housing Practices Act. It amends the definition of sexual orientation. It allows cases in Superior Court. It also allows mediation prior to Superior Court cases, and it prohibits court order unless attorney's fees waiver is signed, and it repeals exemptions to sexual discrimination. Representative, the floor is yours.
Thank you, Chairman Craven. This legislation, I find it kind of interesting that I'm sponsoring it because in 2001, I was the sponsor of the legislation of the bill that is now before us to be modified slightly. Back then, we wanted to make discrimination based on gender and gender identity and all of that illegal. But to get it passed, the agreement was made that an exception would be made for owner-occupied 2- and 3-family dwellings. And thinking about that now, I sort of think we decided that discrimination against somebody who's going to live across the street or down the block or even beside you is not okay, but someone who's going to live potentially upstairs or downstairs is okay. So this legislation, I think we've come far enough in the ensuing 21 years that we need to make it so that this discrimination, even in owner-occupied dwellings, is illegal. And I'd like to read from one of the documents submitted to the committee from a fellow named Damian Lima. He says, I am writing in support of Bill 6215. As a transgender constituent in a same-gender marriage, this bill would help secure my right to fair treatment in housing. I can tell you from personal experience how difficult it is to be denied housing because of who you are and who you love. I can tell you about how difficult it is to have to explain how your name and gender marker are different in your documents, and the phone call that follows telling you that an apartment is no longer available, or the wait for a call back that never arrives. I know I'm not the only one who has lived this predicament. I have seen this happen to people around me. I have seen people struggling to find a safe place to be because of how their gender or sexual orientation is perceived. I write this testimony to ask you to set housing protections right. This bill would provide legal protections to constituents like me who made this state their home. This legislation was brought to me by folks from the LGBTQ community and the Rhode Island Commission on Human Rights. And I think we'll hear from Polly with GLAD and others in support of the legislation. So I'll stop there unless anyone has questions for me.
Any questions of the sponsor? Yes, Doc.
Edie, I commend you for this legislation. I'm curious, on page 3, what was the purpose of lines 5 and 9, and why are they deleted?
I would pass on specific language questions to Polly from GLAD.
Fine, thank you.
Thank you.
I didn't know, the reason why I asked you is if you knew what the historical legislative intent was for those lines, that's all. But I'll hold my question, thank you.
Just, can you repeat the the section that you're asking about, though?
On page 3, lines 5 through 9 are deleted. I was curious why they're deleted, and I also wanted to know what the legislative intent was at that time, that it was included, but now will be taken out, that's all. But I can ask that of someone else.
I can't answer that question. I have no memory of,
Okay, any other questions of the sponsor? Seeing none, let's go to the first phone call. Wendy Becker? Wendy?
Yes.
You're before the House Committee on Judiciary and on Edie Agello's bill, and the floor is yours.
Okay, thank you so much. Chair Craven and members of the Committee on Judiciary, thank you so much for your time. I'm testifying in support of 6215, which would prevent landlords of owner-occupied housing to discriminate against LGBTQ people. I appreciate that the Rhode Island Commission on Human Rights, which specializes in the enforcement of anti-discrimination law, recognized the importance of ending this last vestige of discrimination in housing. This bill would remove the carve-out that was initially established in the 1995 Civil Rights Bill. One that was then created in case landlords didn't want to rent to gay people. It was then included, as Rep. Agello said, in the 2001 bill to allow discrimination against trans people. They were and they remain the only carve-outs allowing discrimination in housing in Rhode Island. I was an activist who worked on passing the bill when it was introduced in the 80s and debated in the 90s. And I remember that the only way we could pass a bill to end discrimination for many was to actually condone it for some. Decades later, we surely know better. We know there should be no carve-out in a law to allow discrimination against a class of people protected by our civil rights law. I'm sure we all now know that landlords' prejudice should not be condoned and certainly not codified in our public policy. I want to thank my former representative, Edie Agello, for sponsoring this legislation, and my current rep, Art Handy, for co-sponsoring it. It is a joy and a relief being represented by two legislators I know care deeply about equality for LGBTQ Rhode Islanders and have in fact both sponsored seminal civil rights legislation for us. And I thank this committee as well. Recent history has shown your commitment to equity and justice for LGBTQ people. I hope you'll continue to support our communities and pass this bill out of committee. Thank you so much.
Thank you, Wendy. Any questions for Wendy Becker? You want to? Doc?
Good evening.
Good evening.
I don't know if you'd heard the question that I asked Representative Agello about.
I did.
Oh, yeah, what was, and I realized that there are similar deletions, not exact, but similar deletions in a couple of other places in the bill. I'd like to know what the legislative intent was for the inclusion of those lines, and now what would be the purpose of deleting them?
So I apologize. I don't have the lines of the bill in front of me. The legislative intent, at least for this part, was to allow people to discriminate. It was many years ago, more than 20 or 30 years ago. So the intent was discriminatory, and I hope we've come farther to understand that we shouldn't be doing that. The specific language of the bill, however, if I'm not answering your question, Michael Avora, who's the director of the Rhode Island Commission on Human Rights, said that he would be happy to answer questions for any members of the committee and will make himself available to do so.
Thank you very much.
Thank you.
Any further questions of Wendy Becker? Seeing none, Wendy, thanks for your testimony. The next witness is Polly Crozier. Polly?
Oh, hello, Chair Craven. How are you tonight?
Good, how are you?
Good.
Well, that's great to hear. You're on the floor testifying on Edie Agello's bill, and you're free to give your testimony.
Thank you so much, Chair Craven, First Vice Chair McEntee, and Second Vice Chair Knight, and members of the committee. My name is Polly Crozier, and I'm an attorney at LGBTQ Legal Advocates and Defenders. Thank you so much for having me here tonight and for having this hearing on this bill, and thank you particularly to Rep. Agello for her leadership on this very important issue. And at the outset, I will note that I think this bill has been put forth by the Rhode Island Commission on Human Rights as one of their priorities, and I know that Attorney Michael Avora, the Executive Director, is not available tonight to testify due to a scheduling issue, but I know, as Wendy Becker said, he's available for questions, and I'm happy to be a conduit to make sure any questions get to him today to flesh, or later this week to flesh out. I think that I'll just make two main points about this bill, which I think is really incredibly important and foundational. First, I think that this important bill removes some key non-discrimination laws and really outdated definition of sexual orientation. I think the language, and I think Rep. Corvesi was speaking to, is really kind of harmful and outmoded language that doesn't represent the public policy of Rhode Island right now and its commitment to justice and equality on the basis of sexual orientation. And second, I will just say that I think the bill also is incredibly important for removing the harmful exemptions from the housing non-discrimination law that currently allows discrimination on the basis of sexual orientation and gender identity. And really, housing is such a critical, basic human right and human need, and it's critically important that Rhode Islanders have access to safe, accessible, and affordable housing. And that the fair housing laws truly protect equally and does not give anyone a free pass to discriminate on the basis of sexual orientation and gender identity. And I think there has been so much supportive written testimony submitted that I saw on the website today, which I think was really wonderful and speaks to, Rhode Island's commitment to equal treatment of its residents and the need to kind of clean up these statutes and really move forward on really a critical human and basic need for Rhode Islanders. I hope you'll swiftly pass this bill. And I want to just address Rep. Corvesi's bill question about that particular language, which I'm happy to go back and do some research on the legislative history. My guess in terms of that language is it speaks to kind of outdated notions of, quote unquote, sodomy being illegal under the criminal code, which obviously the U.S. Supreme Court ruled on those types of codes unconstitutional in the 2003 case of Lawrence versus Texas. So I'm happy to look further for kind of the particular Rhode Island background on that, but I just would say that I think that the language is outdated and really speaks to kind of internal bias at the time.
Yes, Doc.
Good evening.
Hi.
Let me just say for the record, I'm not against the impetus of the bill, or the reason for the bill. I think most of what has to be done, and I don't have a problem with the intention of the bill. That's what I'm trying to say, and especially the couple of paragraphs at the end where it basically makes it takes away the exemption for the discrimination. I don't have a problem with that. I was curious about, as I was talking to one of my colleagues, so I didn't hear, I apologize, I didn't hear everything you said in the beginning. I just was curious about the legislative intent for those lines and why the necessity for taking them out. I'm not necessarily disputing it, but I am curious about it. And again, I commend, as I said earlier, I commend Representative Agello for bringing this forward. I just would like to know number one, the legislative intent for those lines and the need to remove them. Very simple. Thank you.
Well, that's so helpful. And first of all, I think that's really wonderful, your support for the bill. And I will be happy to take a look personally and ask also Michael about the legislative intent of those lines and do some research and get back to this committee on that issue and answer that question more thoroughly.
Thank you.
Okay, any other questions for the witness? Seeing none, Polly, thank you for your testimony. The next witness is Ethan Huckle. All right, Denise Crooks. Denise?
Yes, hello.
You're on the air before the House Judiciary Committee. Please proceed with your testimony.
Thank you, Chair Craven. My name is Denise Crooks, and I'm testifying today on behalf of LGBTQ Action Rhode Island in support of H6215. I'm a therapist with a focus on providing care to members of the LGBTQ community. My patients' experiences of housing discrimination and their fear of experiencing housing discrimination are daily topics in the work that I do. Because of homophobia and transphobia, LGBTQ Rhode Islanders are more likely to lack housing than cisgender straight residents of our state. And searching for a new apartment takes on added stress and anxiety for them under these circumstances. Passing this bill sends a strong message to all landlords. They shouldn't be discriminating based on sexual orientation or gender identity. And more importantly, it increases the possibility that LGBTQ Rhode Islanders will be housed. I hope you will vote to move H6215 to the floor, and that I'll be able to reassure my clients that housing discrimination based on their sexual orientation or gender identity is no longer legal in Rhode Island.
Any questions of the witness? Seeing none, thank you for your testimony. Next witness is David Savatilski, MD.
Yeah, it's letting us know.
Doctor?
Yes.
Hi, you're on the air before the House Judiciary Committee. Please proceed with your testimony.
Oh, here, go ahead.
All right. Well, you know what? We'll just trade phones.
Okay.
This is kind of confusing. All right. I'm going to have to turn off the thing in my ear. Okay. That's weird. All right. Ready? Am I on already?
You are on the air.
Oh, okay. Hello, representatives and Chair Representative Craven.
Thank you.
I'm here speaking about House 6215. I'm a resident of Providence, constituent of Representative Kislak. I work in Rhode Island at a large mental health center, Gateway Healthcare. It's a lifespan partner. I'm a child psychiatrist and associate medical director. In this testimony, I'm not representing my agency, but I would like to offer some illumination of the value that this bill would provide to my patients. Now, when my patients have to move, it is an ordeal at best. If they knew that their financial stability, ability to pay the rent, ability to live peacefully with the neighbors would determine whether a landlord would rent to them, it might be tough, but it would be fair. However, this law allows an exemption for landlords to discriminate purely on the basis of the expression of gender identity or sexual orientation. And it is manifestly unfair and intimidates my patients before they even start to look for safe housing. It has resulted in patients who remain in unsafe situations because they're unable to find a safe place that will rent to them. It has pressured patients into hiding their identities and orientations, resulting in further psychological damage, worsening of depression, raising anxiety. This amendment to the fair housing laws would simply delete that opportunity to express prejudice in the public arena. It makes our state a more fair and welcoming home for all, and I wholeheartedly support this bill.
Any questions for David? Seeing none, thank you, David, for your testimony. Next witness is Eva. It must be your wife.
That's why you got her on the phone.
Right.
All right, Eve.
Hi, yes, I am. So good evening, Chair and the members of the House Judiciary, and thanks for this opportunity to speak. I am also testifying in favor of H6215 to end the current exemption in housing law that allows owner-occupied landlords to discriminate against LGBTQ people. The current law puts them at risk of being denied or even removed from housing solely based on the sexual orientation or the gender identity. I strongly urge you to pass this bill that will eliminate this cruel ability to discriminate. According to a recent survey of transgender adults,
Nearly 1/4 of them reported having experienced housing discrimination within the past year. As the mother of an adult transgender daughter, it's very painful to me and worrisome to know that this experience could easily be hers right here in Rhode Island. As a trans woman, she already faces the potential of being marginalized and humiliated as she negotiates her way in a society that often does not understand her humanity and does not recognize her personhood as equal to their own. As any mother would, I want to help create a world that is more welcoming to her, one where she is respected, her legal rights are protected, and her humanity is acknowledged. Please pass this bill and send a message of support to all LGBTQ Rhode Islanders. And thank you for your time.
Thank you, Eve, for your testimony. I don't see any questions of the witness. Oh, do you have Dave? Oh, you want to be?
I'm still here.
You are here, Madam Clerk. David, Chairman Bennett's here. Absolutely. Please. Great, thanks. Did you get that? No, she's not here. I'll make sure she gets it. Okay, if there are no further questions for Eve, the next witness is Hillary Friedman. Hillary?
Yes.
You're on the air before the House Judiciary Committee. Please proceed.
Thank you so much, Chair. Yes, my name is Hillary Friedman, and I am president of the Rhode Island chapter of the National Organization for Women, and I am testifying tonight in support of House Bill 6215, which amends the definition of sexual orientation with respect to fair housing practices. So one of Rhode Island Now's 5 key issues is fighting LGBTQ discrimination, so this bill is really core to our organizational mission. Repealing exemptions for discrimination based on sexual orientation and gender expression or identity is absolutely necessary for our state to show who we are. So who are we? We certainly don't want anyone to feel or think that Rhode Islanders support discrimination. This bill also makes changes when it comes to hearings in Superior Court, and we support those moves as recommended by the jurists among us. So as we all know, housing is really a human right, and the pandemic has made that clearer than ever before. So we can't allow discrimination in this area of life in our state for any reason, but especially based on any LGBTQI+ identity. So in conclusion, we strongly urge this bill to be voted out of committee and to a full floor vote. Thank you.
Thank you very much. Any questions for Hillary? Seeing none. Next witness is Giona Balvega. Hello?
Hello?
Hello, yes. You're on the air before the House Judiciary Committee. Please proceed with your testimony.
Thank you, Chair Craven and members of the Judiciary Committee. I'm here today in support of House Bill 6215, specifically regarding the repeal of the exemptions for landlords to discriminate against people based on their sexual orientation or gender identity when they reside in the building themselves. It is long overdue that we end this discriminatory loophole. Housing is a major concern for the LGBTQ+ community, and where many people struggle to find housing with already limited options, their prospects should not be further limited based on hate and intolerance. LGBTQ+ people are especially vulnerable to homelessness and housing concerns. Up to 40% of the homeless youth population identifies as LGBTQ+, while only up to 10% of all youth are estimated to be LGBTQ+. They are disproportionately affected by homelessness, and allowing them to be denied housing based solely on their existence is cruel and puts them in danger. I urge you all to pass this bill and end this state-sanctioned discrimination against the LGBTQ+ community. It is our responsibility to ensure that Rhode Island is an inclusive and welcoming home for all people. Thank you very much for letting me speak today.
Thank you very much. Any questions for the witness? Seeing none, the last witness on this bill is Brett Jacob. Okay, well then Brett, we couldn't get in touch with him from the mayor's office, so that would conclude testimony on House Bill 6215, which would bring us to Chairwoman Casamaro's bill, House Bill 6235. It's an act related to human services, abuse, and neglected children. It establishes a military family advocacy program to to address child abuse and neglect in military families.
Thank you, Chairman.
You're welcome.
Chairman, House Bill 6235 comes to us with the support of the Department of Defense and the Commander of the Navy of the Mid-Atlantic region. This allows reporting of child abuse to a military installation when a military child is involved. The military has a statutory obligation to know what is going on with their families. As you know, being in the military is not a 9-to-5 job, and it's a very stressful job and very stressful training. This allows the Department of Defense to go into an MOU with DCYF so that the info is shared at the start of an investigation, not after adjudication. So there are, I believe, 3 letters of written testimony on file with us right now, and I believe we have 1 or 2 witnesses on the phone.
Yeah, we have one witness, Christopher Arnold. Any questions of the sponsor? It's a great bill, Julie.
Thank you.
Okay, let's go to Christopher Arnold from the Department of Defense. Christopher.
Chairman, Madam Vice Chair, honorable members of the committee, the Department of Defense is grateful for the opportunity to support the policies reflected in House Bill 6235 and hopes that Rhode Island will join the 28 other states that have passed similar legislation on this issue. Even one child's life is worth the effort. My name is Christopher Arnold. I am the Northeast Region Liaison at the United States Department of Defense State Liaison Office. DoD relies on working in collaboration with state and local governments to fulfill its statutory obligation to address child abuse and neglect. And you have received written testimony in support of this legislation from Angela Perryman, the Regional Counseling Advocacy Coordinator for Commander, Navy Region Mid-Atlantic. And on behalf of the Department of the Navy and Captain McIver at Naval Station Newport, the Department of Defense echoes their support for the policies set forth in House Bill 6235 and wishes to express our gratitude to Deputy Majority Leader Casimiro for helping to codify state policies that already mirror some of our best practices in this bill. Federal rule establishes policies and assigns responsibilities for addressing child abuse and domestic abuse through the Family Advocacy Program, or FAP. Formal MOUs between FAP and its counterparts in the local civilian community benefit victims by improving coordination on child abuse and domestic abuse investigation. House Bill 6235 protects victims and achieves the DoD best practice of having caseworkers ask clients if they are associated with the military, helping connect victims that are identified as military affiliated with the appropriate FAP rehabilitative, preventative, and other services. Currently in the Ocean State, the present framework relies on individualized local MOUs to guarantee communication between the DCYF and the military community. As we have learned in other states, merely having an MOU is not a guarantee that it has operationalized communication and cooperation. Cases which are not referred to FAP are not afforded the opportunity to receive immediate resources, treatment, and support. Non-reporting of child abuse and neglect cases prevents statistical reporting data by the military. Providing services and managing consistency of information when families are transferred requires a statutory framework, statutory language, and statutory intent to ensure successful outcomes for the benefits of military families and the intent of federal law and rule. DoD respectfully submits that Rhode Island can assist the DoD mission to protect military children and other youth from abuse and neglect by enacting the policies set forth in this bill. As Ms. Perryman observed in her written testimony, we foresee the benefit of having formalized requirements that come from both the Department of the Navy and the state of Rhode Island for an MOU between the commander of the Navy Region Mid-Atlantic Installation Family Advocacy Program and state DCYF. Mutual mandates for formalized agreements will assist in bringing the Family Advocacy Program and DCYF to the table more frequently to ensure each party is clear on their roles, jurisdictions, procedures, and capacities, and that will ultimately benefit the safety of military children. Chairman, DoD appreciates your recognition of the important relationship between the state and local child protective services and the associated FAP offices in responding to and providing support and services to address child abuse. This is not a military law enforcement matter. This is a victim advocacy measure to protect our most vulnerable. We greatly appreciate that the Rhode Island legislature has been a champion in addressing our key military family quality of life issues for the past 17 years. And as always, as the Northeast Region Liaison, I thank you for your time and stand ready to answer whatever questions you may have. And thank Deputy Majority Leader Casimiro for her sponsorship and leadership.
Thank you, Christopher. Are there any questions of Christopher Arnold from the Department of Defense? Seeing none, oh, yeah, I'm sorry, Julie has a question.
Chairman, I just wanted to say thank you to Christopher for making time for testifying on tonight's bill. So thank you, Christopher.
Thank you, Deputy Majority Leader. It's my pleasure.
Okay, thank you for your testimony. That concludes testimony on House Bill 6235, which brings us to our last bill tonight, House Bill 6237, sponsored by Second Vice Chair Knight. It's an act related to courts and civil procedures, small claims and consumer claims, procedures and particular actions. It increases the maximum amount to be recovered in a civil court action as a small claims from $2,500 to $7,000 claims with $2,500, just increases it from $2,500 to $7,000. Jay, the floor is yours.
Thank you, Mr. Chairman. This is I was asked to introduce this bill by Senator Coyne, the chair of Judiciary in the Senate. She has a companion bill over there, and it is what it is. The current cap for a small claims claim in the small claims court is $2,500. It would raise it to $7,000. The reason why we want to do this is that I'm actually going to look it up right now. The cap on the amount of damages that you can seek in small claims is it's artificially low given the nature of business transactions. Today, there's plenty of sort of small bore person-to-person business transactions which might result in a dispute where the amount in controversy may be $3,000, $4,000, $5,000. And what small claims court does is it allows people a place to quickly and conveniently get their claims addressed from a neutral umpire. I've been to small claims court before I was a lawyer. It was a one-day kind of in and out thing. If you have to go to the next level, which is a civil claim in the district or superior court, then that's a much more involved procedure. There's discoveries available there, and it gets very complicated very quick. And oftentimes, the standard civil claims procedure is a deterrent from people seeking redress. So here we just want to make small claims court more usable, and that's the point of the bill. Happy to take any questions.
Okay, any questions of the sponsor? Yes, Edie.
Thank you, Chairman Craven. Vice Chair Knight, when was this number last set?
That is a good question. I'm going to look at it right now. It appears the last time the statute that defines the $2,500 cap was touched was 2004. I don't know why it was touched, but 2004 is the last time it was touched.
Okay.
By the way, its first time it was touched was 1930, so there you go.
Any further questions? Yes, Doc.
And so Edie asked about why the 2,500. Now, why did you settle on 7 as opposed to 5 or 10?
I don't know why 7 was, well, here's the thing. In district court, you can bring a civil action for claims up to $10,000. And then after that, you have to go to superior court. So I think 7 was a number that seemed reasonable and sort of seemed reasonable in that it was and I didn't make this decision, Senator Coyne did, but when I was talking to her, it seemed like a nice middle point between the small claims court and keeping actions there nice and simple so that it go quick, but still giving district court some room in their standard civil action jurisdiction. You know, frankly, I got to say, a lot of this stuff is outdated. I think that the district court jurisdiction over civil claims could probably be bumped, and the superior court jurisdiction for civil claims could probably be bumped as well. Because frankly, if you got to go to superior court with a civil action, you got to hire a lawyer. And if you're going to hire a lawyer, it doesn't make any economic sense unless your claim is at least, I don't know, $30,000, $40,000, $100,000, depending. So there's no reason to go to superior court for 10 grand, and frankly, there's no reason to go into district court civil action for 10 grand either. So all all of it across the line, I think, needs to be bumped, but we're starting with small claims.
So I got to ask, what happens if it's 8,500? Where does it go?
District court.
I think, Doc, maybe I can answer some of your curiosity that I'm interpreting through your mask and on your brow.
Most people can't.
Well, you know, I speak Italian, age 65 and older.
You learned that from your father-in-law.
I learned it in spades from my father-in-law, yeah. Judge Judy is what would kind of, the television program is kind of what small claims court is. You don't need a lawyer. You go up there, you say your piece. The other side says their piece. There's no rules of evidence. There's no discovery. And you can go there unless, just advise you if you have any ideas of doing collections work there. If you're incorporated, you can't do it because then you're representing the corporation and then you'd be practicing law without a license. Landlords often incorporate and do that and make that mistake and find themselves in trouble before the judge in small claims court. But it gives Joe regular guy or Jane regular person an opportunity to go to court without having to hire a lawyer and without all the fanfare. And the district court judges in Rhode Island are very interesting people. They have a way of kind of finding a settlement. And so cleverly, and maybe I'm letting this secret out, they always tell the parties to go out, when they call the calendar in the morning, they tell them to go out in the hallway and see if they can settle the matter. And oftentimes, most times they do. And so if you raise the jurisdiction of the maximum amount in controversy to $7,000, you would have a lot more people going through that process than going through the district court with lawyers process. Now, the lawyers don't have a union, otherwise I'd probably get kicked out of the union if I were a member for saying that there's ways to do things without a lawyer. But I'm a big advocate of that not only do people get their own justice, but they don't have to pay the lawyers' fees, which oftentimes I have to explain to people that sometimes my fee would be more than they would likely get. So I give them my advice and help them fill out the forms.
And I think that echoes a lot of lawyers' experiences when people come to them and they are deeply wounded for something that at the end of the day is what, $6,000, $7,000, $8,000, and you tell them exactly what it is. I would have to, to do what we're supposed to do professionally and competently, it's going to run X amount of money, which is going to be more than the claim itself, and they're left with no way to go to the branch of government that exists that's supposed to resolve disputes, to resolve the dispute because of the economics.
Okay, there are no witnesses, so unless there's any further questions of the sponsor. Oh, David's here, and he would like his vote recorded, except for hold all bills for further study, right?
Yeah, he already voted on
Oh, he did, yeah, okay.
So we can go down to.
Yeah, and so yes, nay on hold all bills for further study, please.
Oh, yeah, Dave, your votes, I already whispered it in Roberta's ear when she was out of the room at the time, doing something far more important than looking at us, I guess, which I agree with her. So that ends our testimony and the bills for tonight's meeting. So do I hear a motion to adjourn?
Motion.
So moved.
Second.
Seconded. All those in favor signify by saying aye. Aye. Opposed, nay. The ayes have it. Thank you.